because Anna and Roger both attended the arraignment of Jim Comey this morning. So most of our audience is probably very familiar, well versed in the circumstances here, but I'm going to help us get our bearings a little bit. So as a reminder, Jim Comey was the FBI director from 2013 until he was fired by President Trump during his first term in 2017, which was a major controversy at the time. He was indicted 2 weeks ago on September 25th amidst some unusual circumstances, including the resignation a few days prior by the then U.S. Attorney for the Eastern District of Virginia, where all of this has been happening, the appointment of a new interim U.S. Attorney who brought charges on her own without the assistance of career prosecutors, which is somewhat unusual. And here we are now on the morning of October 8th, the arraignment of Jim Comey. And Anna Bauer was at the courthouse at 6 a.m. So, Anna, tell us what it was like, remind us what the charges are, and tell us how the proceedings kicked off.
Yeah, so I actually arrived at 5:45 a.m. this morning when it was still dark outside because I am, as our Lawfare listeners might recall, the queen of the line. But this time, actually, we were not first in line. There were already like 5 to 8 people who were outside of the courthouse. That was a little bit surprising to me, to be honest, because if people remember with the Trump trial, it was, people were showing up like the night before, they had line sitters. We kind of weren't sure what to really expect here. Would it be the kind of thing where a lot of, MAGA supporters maybe would show up to get a look at Comey's arraignment? Would there be counter protests, that kind of thing? But everything was pretty calm, actually, and uneventful until we got into court. While we were inside the courtroom, as we can maybe discuss later, there was a little bit of more activity that occurred outside of the courthouse. But it overall was a pretty a small crowd compared to what we are used to for some of these other high profile trials or cases. In terms of the charges, Natalie, just to give everyone a quick reminder of what James Comey has been allegedly indicted for. He's charged with one count of lying to Congress, a false statements charge, and then also one count of obstruction. We think that there's a lot of like speculation that you have to do here because the indictment is very vague. It's very unclear exactly what the underlying conduct is, but we believe that based on some of the language in the false statement charge in the indictment, that this relates to Comey's 2020 testimony before the Senate Judiciary Committee, in which he reaffirmed earlier testimony in which he said that he has never authorized someone else at the FBI to be an anonymous source for a media report about either the Clinton investigation or one of the Trump investigations. The indictment alleges that this was a lie because Comey, in fact, knew that he had authorized someone who was identified as person 3 to serve as an anonymous source regarding a story about person 1. We still do not really know who person 1 or person 3 is. And we learned today in the arraignment that, in fact, Comey's own defense team also does not know who person 1 or person 3 in the indictment is. But that, Natalie, is kind of a brief refresher on the charges here. And so today's proceeding, the arraignment, is essentially just a proceeding that allows the defendant to have notice of the charges against him, his constitutional or statutory rights, and then also an opportunity to enter a plea. As expected today, Comey entered a plea of not guilty.
Okay, and Roger, tell us what the judge's tenor was, because this case has obviously gotten a lot of attention. The unusual circumstances leading to it, as I said, have been somewhat unusual. As Anna reminded everyone, the actual indictment was extremely short, very unusual in terms of the limits on amount of detail. So for an arraignment where, as Anna described, the purpose is for the defendant to understand the charges against him, we didn't walk in with a whole lot of understanding of what that would be. So how did the judge respond? What were the dynamics like inside the courtroom when those basic conditions of business got underway?
Well, he was pretty poker faced, but he was brisk. The Eastern District of Virginia has a reputation as being one of the country's rocket dockets, and he definitely wanted to keep things fast. In fact, he indicated that he would have set the case for the speedy trial date 70 days from the start of December 17th, but both sides wanted a little more time than that. Um, uh, uh, Fitzpatrick wanted, Patrick Fitzgerald wanted this January 12th, and he moved that up to January 5th.
For the trial date, you mean?
Yeah,
Okay.
the trial date. He also, the government indicated that it had a large amount of classified information, which it had not gone through and needed to. And he was very skeptical about the need for a whole lot of classified information. It seemed like the charges were very simple. Relatively simple. He wanted the government to really concentrate on what it needed. And he said, if you need something to the effect that if you need a SEPA proceeding, those are the Classified Information Procedures Act proceeding, it's going to be the fastest SEPA proceeding you've ever seen. So he was really moving things along. Fitzpatrick doesn't have, Fitzgerald, Patrick Fitzgerald does not have his old clearance, so he wants the government to get him the clearance immediately. He had one from decades, just get him the clearance. His co-counsel has a clearance, Jessica Carmichael, so he was just moving things along.
Okay. And so, as a reminder to folks, Patrick Fitzgerald is Jim Comey's lead attorney, but as I understand it, he has at least two others.
I think he and Jessica Carmichael are the only ones that have entered appearances so far. Okay. Is that your understanding, Anna?
I believe so. For some reason, I thought at one point someone mentioned David Kelly was joining his team, but I maybe that was reported. But he was not there today. I will say it was Jessica Carmichael, who is the local counsel, and then Patrick Fitzgerald, who used to be the U.S. attorney in Chicago, who has known Comey for a long time, is a friend of his. In the courtroom, to just kind of give you a sense of who else was there as well. Comey's family appeared in the gallery, including Maureen Comey, who, as many people will recall, was abruptly fired from her job as a prosecutor in the Southern District of New York. His son-in-law, Troy Edwards, who recently resigned from EDVA, or the Eastern District of Virginia, was also in attendance, and other family members. Fitzgerald, who is Comey's lead counsel, when he made his appearance before the judge, started by saying, "It is the honor of my life to represent Mr. Comey in this case." And then, Natalie, on the other side,
this is my next question.
Yeah, I was anticipating it, and so I'll just go ahead and jump ahead.
Please.
On the other side, we had Lindsay Halligan, who is the very recently appointed acting or interim U.S. attorney. We're not really sure which one and under which authority she was appointed, but is currently in the job of the U.S. attorney. She replaced Eric Seibert, who resigned following reports that Trump was unhappy with his decision not to move forward with a prosecution against Comey, or his expressed reservations about the case, at least. And then also following Trump's public social media posts in which he put pressure on Pam Bondi to move forward with these prosecutions against some of his political enemies, including Comey. He then puts Halligan in, and within a matter of like 72 hours, she goes before the grand jury herself, in a highly unusual and irregular move for a U.S. attorney to do that. Presents the case, and Comey, as a result, is indicted on these criminal charges. I will also mention that Lindsay Halligan is Trump's former criminal defense attorney. She does not have experience as a prosecutor. So with all of that in mind, it was clear that this prosecution would need actual real prosecutors on the case to take it to trial, if the intent of the government really is to take it to trial. And for several days, it remained unclear who that would be. Then yesterday, I believe it was, we got our first answer to who would join the trial team. It is Tyler Lemons, who also, I believe, goes by Nathaniel on the docket, but his name that he uses is Tyler, and Gabriel Diaz. Both of them are AUSAs who are being detailed from the Eastern District of North Carolina. Both of them, I believe that the Gabriel Diaz is the one with a little bit more prosecutorial experience, in that he joined the department in 2018, I think it was. Roger, correct me if I'm wrong on that. But Tyler Lemons also has, several years of experience as an AUSA. So I'm not entirely sure how much experience they have with false statements or obstruction charges. And I'm also not sure if they have any experience with issues around classified information being used in criminal cases, and how CIPA, the statute that kind of regulates the introduction of classified materials in a criminal trial, I don't know that they have any experience with that. But we did learn today, as Roger alluded to in his remarks, we did learn today during the arraignment that according to the government, there is a, quote, significant amount of classified material. It's not really clear exactly why or how that would figure in a trial. It's also not clear what the government plans to do in terms of, will there be a CIPA process to use classified information at trial? Or will the government declassify that information? Tyler Lemons, who was the one who spoke on behalf of the government, seemed to suggest it might be the latter with respect to declassification.
Okay. I want to come back to the CIPA questions, because it is, I think for some of us, it was a bit surprising that came up at this stage, and I'm interested how it presented itself, because I know you had both mentioned before we got on this that they already spoke about deadlines for certain motions that Comey's team mentioned that they would be bringing, some of which I think are pretty unsurprising, namely the selective and vindictive prosecution, motions to dismiss. It's technically two separate motions. And I guess others another that was expected as well, a challenge to Lindsay Halligan's appointment as U.S. attorney, including, and as you mentioned, because it's not clear under what authority she was appointed, and under either option, there may be some problems with the legal parameters and the procedure by which that was done. But then it sounds like there were some other motions as well. So Roger, maybe you can tell us what we learned in terms of the motions that that Comey's team is planning to bring, and anything the government said in response that would sort of indicate what we can expect will come next.
Yeah, Fitzgerald proposed two tranches of motions. The first will be due October 20th, which is pretty soon. That's the ones you mentioned, the malicious prosecution, I think he did call it malicious prosecution, but But then he sort of, I think he corrected himself and said a motion to dismiss based on vindictive or selective prosecution.
And I'll just note for our devoted fans that we do have an article in Lawfare explaining the basic parameters of selective and vindictive prosecution motions for anyone who wants to get ahead of the briefing.
And then the challenge to the lawfulness of the appointment of Halligan. And those will be coupled together. And I think they will sort of, at least the second one will sort of help the first one because it conveys in the factual run-up, the sort of frenzy of activity in order to meet Trump's demand that he be indicted quickly.
And I assume that too will be styled as a motion to dismiss.
I assume so too. There is, I do assume that. There might be a defense of sort of de facto authority. I just don't know what whether there's any leeway to a remedy if somebody is, in terms of, certainly you change the prosecutor, but whether you need to dismiss the case, I don't know. Both of those are due October 20th, response due November 3rd, reply due November 10th, and then oral argument November 19th. The second round is a motion to dismiss based on grand jury abuse and a motion to dismiss based on outrageous government conduct. And those he'll brief October 30th, response November 13th, reply November 20th, oral argument on that December 9th. So those were the ones I mentioned. By Friday, he's hoping to get a discovery order, ideally if both parties can agree on that. One thing I was a little surprised about was there was no explicit reference to bill of particulars, but I assume that's subsumed into the discovery order that he hopes to get. If not by Friday, they'll submit briefs on Monday about what they want and what the areas of disagreement are.
Okay. Yeah, I was going to ask about the bill of particulars. So that didn't come up today in the proceedings?
I didn't hear those words, but like I say, maybe it was folded into everything that's in Rule 16 and all the other discovery that's possible.
Okay. Yeah, because it will be quite a process to watch, given, as we discussed, how little detail there is about what the charges are and the factual basis for them. So is your sense that the discovery is likely to be focused at this point on in furtherance of the motions that are forthcoming, or will it be sort of a more generalized discovery process to the extent we can know at this point, which maybe not at all?
We didn't hear anything about that, at least I didn't. I think if they can't agree on discovery, I guess we'll know more about that Monday when they file their motions.
Okay. And Anna, you had both mentioned SEPA earlier. Did the discussion of possible SEPA procedures come up in the context of the motions that would be coming, or in trial generally?
Yeah. So look, at one point, keep in mind there's the Speedy Trial Act and this deadline where they were kind of working out, should we set the trial within this deadline? That's December 17th, according to the prosecution and defense. Everyone agreed that would be the current deadline unless there's later accepting days that are accepted because of motion practice stuff and that kind of, intervening events. And so the judge wanted to know, like, okay, do we want to set the trial date for within that deadline or outside of that deadline? The defense initially was the party who said, let's set it for January because we think that we're going to have these motions that's going to, that will need to be litigated prior to trial. And then the judge wanted to hear from the prosecution on this. And so the judge said, hey, like, do you agree that it should be outside of the Speedy Trial Act deadline? Do you think it's possible for the government, will the government be prepared inside of that deadline, before mid-December? And it was really pretty remarkable because Tyler Lemon's response to this was, well, we want to honor the defense's request, but also we, the prosecution, are just getting our hands around some of the discovery, and there's lots of it, and a significant amount of it is classified information. And I think that, the reason that was raised was to try to say that this could be complex dealing with this issue of classified information. So that's one reason why we want to push it outside of the deadline of December 17th. So that's kind of one of the contexts in which it was raised. It also came up at multiple times because it was raised by defense counsel as well, that there are clearance issues. As Roger mentioned, Fitzgerald doesn't have clearance anymore. Comey doesn't have clearance anymore. The only one who does is Jessica Carmichael. So it came up multiple times, but that was it, to my memory. Roger, correct me again if I'm wrong, but that was the initial context in which it came up, was the government trying to explain, why they needed maybe a little bit more time. One of the responses from Fitzgerald to that was, something to the effect of, this kind of is the government put the cart before the horse here, because usually the government would come into a case, already having its hands around all of its discovery, or not all of it, but the vast majority of its discovery, and then B, would have consulted with the National Security Division, other DOJ components as necessary to figure out equity holders in terms of where the information is classified. So, they would have usually done all of this before going into charging a case and going into the arraignment and have some sense of how they're going to handle it. But here it was very clear that they just didn't have much of a sense of it at all. And again, I'll mention that it's unclear to me if obviously Lindsey Halligan was on Trump's defense team, kind of in the background in his classified documents case, but I am not aware of her being, someone who has a lot of SEPA expertise. I also don't know if Tyler Lemons or Gabriel Diaz have any experience with that either. That's not to say they couldn't get assistance from other DOJ prosecutors or components who do, but again, these are the kind of usually the things you have figured out, or at least some sense of it, before you go into an arraignment.
Yeah, if I could
Sorry,
add,
go ahead,
that's, and Fitzgerald said at one point something like, my client should not wait around while they go through things they should have gone through before. It was very strange. Obviously, these prosecutors are very new to the case themselves. One thing Fitzgerald said is that he only had one substantive conversation with the prosecutors, I think yesterday afternoon. And so I think everyone was I think the defense and the judge were skeptical that these SEPA documents really have much to do with the case.
Yeah, so
he did directly try. Oh, I'm sorry, Natalie. Just really quickly, I will say, I want to make sure that Roger and I had the same understanding of it. To my memory, the judge did try to directly ask, will this be necessary? Like, is there some sense that you can give us of how this will be used at trial? And there was never really an answer to that, right, Roger? It seemed like they weren't even sure, maybe.
He was skeptical. He reminded them they have the power to declassify if that's necessary. And then he said this thing about, if there's a SEPA proceeding, it's going to be the fastest one you've ever seen.
Yeah, I'm curious what you guys think. We sort of have to guess at this point because we have so little information in the indictment about what the factual basis of the charges might be. And it sounds like what we were saying is that this came up in the context of how long it might take to even get to trial. And of course, as you say, SEPA proceedings are very slow traditionally, even when they're fast. They are just quite time consuming. And so, other than knowing that it is something that the government can raise to explain why it may take a while to get to trial, do you have any sense of what would be classified? I mean, what we know about the charges is that they relate to statements to Congress, and which are obviously public, that relate to possible disclosure of information, and the other charge just being obstruction. So, what do you think the classified information at issue might be?
Anna, do you want to take that first, or you're muted, I think.
Oh, Natalie, I honestly have no idea. I mean, I will say that, so, and part of it gets to the fact that we don't know what the underlying conduct relates to. We don't exactly know. We don't know who this person 3 is that Comey supposedly authorized to serve as an anonymous source. The allegation is not, though, that Comey leaked classified information or that he authorized someone else to. But with all that said, there have been media reports in which sources familiar with the prosecution say that this all relates to Comey's relationship with Dan Richmond, who was his friend and who served as a special government employee. Sorry, am I still, are you guys able to still hear me?
Yeah, you're breaking up a little bit,
Yes.
but I think, it is just
Are,
remarkable
I,
to me that we're not sure. Oh, I think we lost Anna. Hopefully she will be back. But yeah, I think it's interesting. It was one of the reasons I was asking about whether this came up in the context of the motions. Was I wondered whether they expected to need to have SEPA proceedings relating to discovery in the motions, but it sounds like we just really don't know.
Yeah,
I
yeah. Oh, sorry. Am I back?
You're
Can you
back.
hear me now?
Yeah.
Okay.
Yeah.
I apologize, and I don't know what was said while I was gone. But just to briefly wrap up, basically, if it is, as it has been reported, related to Dan Richmond, who briefly was a special government employee at the FBI. And there was an investigation previously that did not result in a finding of anything sufficient to lead to criminal charges, but that investigation, I believe, related to the potential disclosure of classified information. And as a part of that investigation several years ago, it focused on, Dan Richmond and Comey and, contacts with the media and that kind of thing. So again, like, it could, to be very speculative, like maybe there's something to do with that investigation or what the alleged disclosures were, but we really don't know. It's so unclear. And it's not clear why it would be necessary to introduce that at a trial that is not alleging anything about classified information.
Yeah, I think my takeaway, frankly, from what you're both saying is that it just really underscores how little we know about the allegations and what this case is even about. And so that will definitely be something to watch as discovery unfolds. I think motions in this context of uncertainty can be particularly revealing, so we will certainly keep apprised of the briefing there. I want to end with one last question, which is just to note that soon after the indictment, Jim Comey put out on social media a video of himself saying that he was eager to go to trial, basically. We had some discussions internally about whether that would happen, and I will just say, I had said that no defense attorney in their right mind would skip pretrial motions to dismiss. So I'm feeling a little vindicated. But I'm just curious if you had any thoughts on that, and if you got any sense of the dynamic in the defense team while you were in court today.
I took that statement to be more like game on rather than let's literally go to trial. He's obviously going to try to dismiss this in the pretrial motions. And, you know, you're not stopped by saying something like that from bringing pretrial motions. So I just meant let's get it on. And he also, one possible motion he mentioned as well was something like a motion to dismiss based on truth. I think he suggested there might be, depending on discovery, there might be other motions, and one would be, and that would be one I would expect, a motion to just, it's true as a matter of law, what he said, given what they're, you know, whatever they're comparing what he said to and saying there's a disparity here. I think he's going to ask the judge to look at the two and say, is there really a disparity? And that would be a motion to dismiss.
Yeah, I mean, I agree that I think that it's, you know, one, it was not necessarily literal, but kind of more of a, you know, game on type of statement. But also, you know, Comey is a good lawyer himself. Like he knows the law. He knows how these things work. He has a fantastic defense team. I think that it's completely unsurprising that they're going to exhaust all of their options by, you know, doing the appointment challenge, by doing the vindictive or selective prosecution motions, and even those like those vindictive or selective prosecution motions might very well involve a kind of mini trial of sorts, but not of Comey necessarily, but of the prosecution, because you could get an evidentiary hearing, and you know, a lot of these issues may very well be a kind of mini trial situation that comes out during that evidentiary hearing. So I think that's notable. One thing I will mention though is that I was a little bit surprised about, and Roger, maybe, you know, you recall or remember something different, but I don't think there's any mention of a bill of particulars being filed. Am I right about that, Roger? So, and just for people who don't know, a bill of particulars is something you might file, because we've been talking about how vague this indictment is. And Comey's defense team told the judge today that they still don't know who person 1 and person 3 is in the indictment. And what you could do is file a motion for a bill of particulars that kind of would require the prosecution to set out the factual basis of the indictment in a more detailed way. Roger, was that surprising to you that there wasn't a mention of that today?
Yes, and my assumption is that it's being wrapped into the discovery order that they're supposed to provide either Friday or file motions about on Monday. That's my assumption.
Yeah. Okay. Well, yeah, I mean, as I often say, and you both know very, very well, trials get all the glory in terms of attention, but a lot of interesting stuff can happen during discovery. So we will keep an eye on it, but I want to say thank you so much to both of you for being there to cover it for us and for jumping on today.
Thank you.